Good evening, everybody, and welcome to Wednesday Night Live from Courtroom Confidential, the fastest growing true crime news channel on YouTube. Tonight's going to be fun. Tonight is very exciting. We got a lot of really interesting stuff to talk about. Some just fireworks. Not to overuse this term of you never see this happen, but you never see this happen type stuff in court. So I asked Kaylin ahead of time, how are you feeling before we started? And she said she's juiced. I am juiced. You all should be. And I know why you're here. I know why we've got a lot of people already in the chat. I know that you're all here to see our friend Scott from Recovery Addict. He is waiting to come on. I want to introduce him. What we're going to do is we're going to talk about all this craziness that happened in the Zachary Hughes case today. And Scott was there for every single minute of it, watching it live with all of his viewers, and they were in for a treat today. And then if we have time, who knows with everything there is to go over tonight, but we always like to do a poll to see what you guys are interested in. And if we have time, we'll get into it. The poll is tonight for this evening is going to be the ASAP Rocky case. He was found not guilty. We could talk a little bit about that. His reaction in court, by the way, if you haven't seen it, is pretty wild as well. We have some footage of that. We could talk about the Jay-Z case, how the civil suit against him was dropped. And what does that mean for Diddy? And what does that mean about going forward? And what are the ramifications of that case being dropped by the plaintiff? And then James Ferguson is a case here in California that is not getting as much attention, but it really should. It's about an Orange County judge who shot his own wife. And it was after she had kind of dared him to do so, if that makes sense. He had pointed finger guns at her, and she said, "Why don't you use the real thing?" So he pulled out the real thing and shot her dead right there, and then confessed to everybody who would listen about it. So he's going on trial, and it's just beyond all the things that are fascinating. It's fascinating because he is a judge. He was a judge sitting in criminal courts in Orange County, and now he's in a very different spot, sitting in front of a different judge, finding out whether or not he's going to go to prison for the rest of his life. So that's our poll. We will put that up now. As always stated at the end that we have announcements, but I'm not going to make you guys wait any longer so that we can bring on our very, very special guest. Please welcome Scott from Recovery Addict. Hello, my friend. How are you?
Josh, it's great to be here. I'm super excited. I'm still just shaking.
You're a little
from
buzzy.
Today.
You're a little still tingly from everything that took place today.
Yeah, jaw on the floor, still trying to pick that up. It's been a wild day.
Yeah,
in courts.
yeah.
We've had crazy days before, but this is like on a new level. I haven't seen something like this.
And you've been watching trials for long enough, and I've been doing this my entire adult career, that you don't really get to say that all that much. I haven't seen this before. Boy, this is a day I'll remember for a long time because there is so much craziness usually, but this is on another level.
Yeah, I mean, it's always fun to see something new. Like the first time you watch a sequestered jury trial, it's like, that's a little different.
Right.
The first time you watch, you mentioned a trial where the judge is the defendant, that's a little different. But those stories happen now and then. What I've seen today, I've never seen anywhere else.
No.
I don't know how else to say it. It was so many times that we thought it was like, to take it back to the beginning. Okay. When the trial started, we like to joke about having a little bingo card, right? And there are things that come up. Walmart always seems to be mentioned in every trial, and you've got all these little facts, and everyone's like, "Oh, right. Bingo!" We heard all the little check boxes. This one began, and we're hearing about cloned phones and airport proposals and international child custody disputes with the Hague Convention involved. And it's like you never hear these things in court, and that was the prosecution side. Defense got up and took it to a whole new level today.
Oh yeah. Yeah, the wheels came off today, literally. Well, not literally. I don't want to overuse that term, but the wheels came off on this trial. And I'll be honest with you, the way things stand right now, I don't know how it's going to proceed. Meaning, I don't know if it is going to proceed, but if it does proceed, how will it proceed is really kind of an open-ended question, because it is one of those things that you just do not see happen. So there's not a lot of experience for people to fall back on. Before we get started, I want to say that you look especially sharp this evening. You seem to be a very sharp
It must be my
dresser
camera.
nice.
Look at that.
Twinsies. Tisha S
Love it.
says we're twinning. We are.
It's a great shirt. I highly recommend it.
Oh, thank
And
you.
he didn't
Thank
pay
you
me
for
to
your
say that.
support. You're always incredibly kind to us and to the channel, and so we really appreciate that. And for coming on tonight, you're coming on a little bit of short notice. I will say we love having you on, but we had talked to Gigi from Recovery Addict about coming on, but she's got other obligations where she's kind of boots on the ground for some news channels, and so she needed to do some reporting and didn't know if she'd be able to squeeze in enough time. And I felt like we need to really dedicate some time to this. And we were watching you during the day, and I turned to Tiffany and I said, just text him, see if he'd be willing to do it. So while you were still live, you're responding to us saying, yeah, I'm in. So that was fun, and I appreciate you being so kind of flexible.
Yeah, you've got to give props to Gigi. She's been in the courtroom watching this and live tweeting. We're at a sort of disadvantage because the way the judges ordered this, anytime the jury's out of the courtroom, the camera audio has to be turned off, and we don't get to see what happens. So Gigi has been filling in those blanks. We've got some people from our channel there as well. Christy's down there. You've got, Law and Crime has their people. We've got Fitz News. Just some great reporters in the courtroom keeping us updated on things we don't get to see, and that's where some of the big spice has been.
Good. And for Gigi, she picked a heck of a case to be like, I'm going to go watch this one in court. I mean, it sounded interesting to begin with because, everybody's been calling it the Rose Petal Trial and all of that stuff. But boy, I don't think anybody knew what she was in store for. So, Scott, if you don't mind, give us just like the briefest version for people who may not know all that much about the case. It's a gentleman by the name of Zachary Hughes. The victim's name is Christina Parcell. And there's these allegations that well, first of all, Hughes is on trial for murdering her, stabbing her to death. She had a child with a man by the name of John Joey Mello. And until today, it was kind of just the prosecution theory that Hughes went in there, maybe in cahoots with Mello, maybe not, maybe taking it upon himself, but ended up killing this poor woman. But there's kind of my setup. You tell us a little bit more about what's going on.
Until today, it was a whodunit. That's what this case was. Can the state provide enough evidence to prove that the defendant committed this crime? And it's. I don't know how you can boil it down to a 5-minute, summary, because this is a twisted web. There are so many players that connect differently, and you sort of have to have a chart and a graph and a little strings and red string and pins to put pieces together.
You need the cork board and the push pins, the crazy wall to connect it all. Yeah.
But the defendant was a friend of Mr. Mello. Mr. Mello and Christina had a child together. The defendant met Mr. Mello in a park while he was sort of busking with a keyboard.
The Hughes is a classically trained pianist.
Like
that's the other kind
Juilliard level. You don't get much better than him. Just incredible. I mean, he performed with the orchestra and everything. And so they met, and he said he felt this connection immediately with the child, with Mello's child, who becomes a major part of this case that the judges said we really can't talk about. But the child was very attentive, was very interested in the piano, and so he sort of felt this connection. And as his friendship with Mr. Mello continued, he kept being interested in the well-being of this young girl. Custody battle ensues between Christina and Mello. Mr. Mello goes to Italy. There's a point where he takes the daughter to Italy, and the Hague Convention involved. Senator Lindsey Graham steps in. They're trying to negotiate and fly the girl back. There's a proposal at the wedding when they bring her back from not Mello, but from Mr. Post, who was the fiance of Christina.
Right.
They turn out to be a bad couple, according to allegations. Mr. Post is currently incarcerated for something that the police found out when he called 911 to report the body of Christina.
Right.
So you've got every time I try to start this, I don't know where to begin.
Yeah.
Because it gets so convoluted. Christina was murdered in her house. Mr. Post boyfriend shows up, finds her dead, calls the police. The police, in their investigation, clearing him of anything, take a look at his phone. His phone has some bad stuff on it that implicates him, allegedly, and Christina. inactivities
And the
with
child.
the daughter. Yeah,
Right.
illegal.
Right.
Um,
Bet you guys can use your imagination
we
about
don't
as
have to
bad as
fill
it
in the
can
blanks
get.
there.
Involving a child, and this man, and photographs and everything else, and lots of it apparently. Right, like tremendous
Terrible.
amount of this
Terrible.
this evidence.
Yeah. The where Mr. Hughes here comes in. Mr. Hughes was friends of Mello, did some work for him at one of his houses, cleaned it out. Also worked with Michael Manigault, who was a gentleman we saw briefly, a funny guy that briefly appeared. But Mr. Hughes became like really close to Mr. Mello. He takes an interest in what's going on in the relationship. Mr. Mello's saying, hey, we're having this fight. And Mr. Mello starts disclosing some of this bad stuff that he believes is going on with his daughter when the daughter's with Christina. And Mr. Hughes gets this under his skin. He thinks it's wrong. It's because he feels for the daughter. He's like, this shouldn't be happening to this girl. It's like protective. And he becomes obsessed about it. At one point, Mr. Mello broaches the subject and says, hey, would you, for $5,000, kill Christina? That would solve the custody problem. And he's like, no, I can't believe I would never, right? I can't believe you even asked me that. And a couple weeks later, he's like, how about 10? 10K
Okay.
enough?
Yeah. And I don't want to cut you off, but before his testimony today, we had not learned any of this, right? The prosecution had not let on about any of this involvement with Mello or even a motivation really for why Hughes committed the crime, correct? It was just kind of a straightforward, he was ID'd here, we found some DNA, here's the Ring camera footage, all of that stuff.
I probably should start with the right chronology, but in the defense opening statement, which was deferred. So instead of giving it at the beginning of the trial, they waited till the prosecution had finished their case with all their evidence, and then they stood up. They said, "Hey, we could have attacked the evidence. We could have attacked the DNA, the chain of custody for the DNA. We could have attacked the enhancement of the videos of the bike, because let me tell you, that guy on the bike is like 7 feet tall, and Mr. Hughes is not that guy. We could have done all these things and attacked this case like you normally see a defense do, but we're not doing that. In fact, you're going to hear from Zach, and he's going to tell you that he killed Christina, and he's been waiting to tell you why."
Incredible.
And that was the moment that just, I mean, it shook me. Just
well,
like,
I know how much it shook you, because in talking to you, I called into your show earlier today and said that I wish I had a meme of the reaction on your face when you heard that in court, and your people came through, because Amber or Calypson's Vixen, Kaylin, if you have it queued up, sent us this clip from your reaction the moment that you heard the defense theory in court. And I will tell you this, the look on your face is shared by all of us.
Now, the why to a case like this is very important, because it goes to the heart of the matter, and that is malice. Malice is what makes a homicide a murder.
That's fantastic.
Yeah, I can't play cards with any of y'all.
Yeah. That was the moment. I mean, it was just like, what? Wait, because you didn't really see this coming earlier through the cross-examination, right? It did not seem like they were setting us up for this.
No, the state was trying to prove their case. They had to build all the evidence to make us convinced that it was him. And then defense got up there, waved the white flag, and said, we did it. We did it right here. Wait till we tell you. We did it. And they surrendered on everything. And that's, I mean, the jury, if you look at this from the jury standpoint, they're not allowed to take notes in this case, right? So they have this
incredible
web,
by the way.
Yeah, I don't
just
like that.
Bizarre beyond belief. But okay.
There's a web of people that connect in different ways, and all these people in relationships that happen at different times, and how they met each other and how they work together. The jury's trying to keep that all straight in their head. I can imagine this, right? So defense gets up, and the first thing they do is to say, don't worry about that. We're admitting everything, but we're going to tell you why we did it, which was a defense of others.
Which gets into some really interesting legal points too, because in defense of others, They want to get this evidence in that you alluded to earlier about what was taking place with the child and whether or not the child was subject to certain kinds of unspeakable abuse, both at the hands of this fiance and at the hands of her own mother, correct? That
That's
the
the
mother,
allegations.
right. Those are the allegations, right. And that Hughes believed this, and that Hughes, in an act of protection for the child, did what he had to do, or that was going to be kind of the proffered evidence of what he was going to testify to. And the prosecution challenged it, and the judge agreed that that's not how self-defense or defense of others works. You have to show imminent harm. In other words, you can't say, I'm going to use deadly force to protect someone for potential future harm, but it has to be happening in the moment that you're stopping it. And so because of that, they weren't allowed to get into that evidence, correct?
That was the judge's ruling. But as we saw today, the judge's ruling didn't stop the defendant from going there anyway.
Yeah, let's talk about that. One more quick point on this. I was thinking about this today. This kind of goes back to, not to get too far into the weeds, but the Menendez brothers case. That case had a similar argument in that they weren't allowed to, in the second trial. The first trial they were, but in the second trial, they had this taken away from them in a similar way as the judge made the rulings today. They were trying to say that they were defending themselves from the abuse from their own father. And that's why they acted the way they did. And the judge said, no, you haven't shown that it was imminent. You can't say that I didn't want to wake up the next morning and face this nightmare again. You have to have said it was happening then, and that's why I needed to use such drastic, deadly force. Because they didn't demonstrate that, the judge didn't allow that, which is the same reason he didn't allow it here. But to your point, Hughes was having none of it. So set us up a little bit to what happened, and then I have a clip I want to show everybody.
Okay, so when Hughes takes the stand, we start by learning about his life. He was born in California, moves to Virginia, about 15 years old. They moved to South Carolina. I think it's a Travelers Rest area. By that time, he knew he was going to be, he wanted to be a musician, a performer, in the music world. And while Hughes is telling this story through the questioning from his attorney, he has a proper posture, a very even sort of demeanor about him, and a very deliberate answers. He leans forward to the microphone and clearly speaks his answer, and then resets to this position. And it's sort of unique. It's like a performance, but it's extremely consistent. His blink rate is very low for those that are concerned about, his blink rate, and he's making eye contact. He's communicating at a higher level than just saying the words and expecting them to be heard.
He seems unbothered.
No, there's no remorse. There's no shame. There's no, he seems like completely at peace with where he is in this. And that in and of itself, as he's telling this story, is crazy. But he goes on, he tells his background. He tells about his parents adopting 5 Russian children. And the oldest one was Yelena. I think Yelena. I can't remember what it was. Her name was Yelena. They changed her name to Grace when they adopted her. And he starts to say, to understand my actions in relation to why I'm here, this crime I've been charged with, you have to know what happened with my sister Grace. And of course, the prosecution, objection, they don't go there. We think this is a backdoor way to get to that issue that the judge said you can't bring in. It's not admissible. The judge allows him to move forward. And we're all expecting him to say, my sister had been through a similar experience or something. And he says, my 10-year-old sister is the most evil person I've ever met. And we're like, whoa, excuse me?
Yeah.
And he proceeds to describe her as just the cold-hearted, then just everything terrible, everything evil. He says she has shark eyes. He describes her as a vampire, just sucking the life and the will to, all goodness out of people around her. And he says, and that's exactly what Christina was. Huh. They were the same. Mr. Mello. Now, he had never met Christina. As a matter of fact, he didn't even recognize her when he showed up at her house to kill her.
Wow.
He had never met her. Everything he knew about Christina was from Mr. Mello. he had never witnessed any of this alleged abuse, that he was, you know, the reason why he's doing this. And it just blows my mind. They go on, and every time they get approached to the reason of why he does this, he gets too close, right?
Yeah.
I think you've got a clip of him doing this. I'm not sure what you're going to do. And there's an objection from the state.
Right.
And, you know, rightfully so. The judge has ruled pre-trial it's not coming in. And the objection sustained. And, and the judge tells the jury, unring that bell. We're going to put that toothpaste right back in the tube, pretend that didn't happen. And now let's move on. And it doesn't stop. Every time he keeps telling the story, every time he gets to that, that point, he says, and this is the reason why, because there was abuse that was happening at the hands of her mother. And they're like, whoa, objection. And he gets admonished by the judge saying, hey, you can't go there. And he does this, I understand, thing to the judge. We didn't see that all in person. We heard that from court watchers. And he did understand, but he had no intention of complying.
Yeah. And so this happens like 2 or 3 times, right? And then finally, well, I don't want to mess up but at some point he even gets threatened with contempt and being sentenced to additional time, right? From the judge. It's like the judge is pulling his hair out, trying to figure out how to stop this.
It happened. He has a 6-month sentence that the judge has levied on him because of his contempt of court. So he could be found not guilty, you know, presumably in this case, and he would still be serving 6 months for contempt.
Incredible.
For what he did. But he's just, I understand. And
so, go ahead.
He shows that he really wants to get this story out. And it also shows that he really sort of believes in the reason why he did this. And that would explain why he has the demeanor that he does, why he's so confident, why he's, you know, has no shame, remorse, or anything else in front of the jury. It's bizarre and it's wild, and I can't stop watching it.
It is one of those things where you can't kind of peel your eyes away. I want to play kind of the culmination of all of this when he's already been admonished more than once at this point about not bringing up this information. And like you said, says to the judge, I understand. And then it kind of culminates in this moment right here. And then after that, let's take some questions, because I know we're getting a lot of questions from people watching, but let's just watch this really quick. Just make sure, Kaylin, to let me know that you guys are hearing this.
I was still completely freaking out, and it felt entirely surreal. But there is a big difference in how I felt, in that as soon as I left the house, I felt the most enormous wave of relief wash over me, because I knew from that moment on, Aida would be safe. Aida would be safe from the sexual abuse that her mother was perpetrating on her. And there is proof to that the state is hiding from you.
Your Honor, instruction to be quiet. Okay, you need to stop talking. The jury.
Okay, so that the judge then excuses the entire jury. This is a nightmare for the judge. But you heard people are objecting, or the prosecution's objecting, and he's just speaking over them, and not only just saying the thing that shouldn't be said, but telling the jury now, and the prosecution is hiding this from you, which is, to me, is probably even more problematic than him even saying the thing that shouldn't have been said, right? Because now he's making it, now he's casting aspersions on the prosecution as if they are being deceitful to the jury. So let's take some questions, but that kind of that wasn't the end of the day, correct?
There's a little bit more,
Okay.
but that was pretty much the how the fireworks ended for the day, and we don't know how it's going to continue tomorrow. I mean, that's the big question.
Which everybody has kind of gone back to their camps to figure out how they want to proceed on this thing.
Mm-hmm.
DK, thank you so much. Ask the question, Josh, if the judge declares a mistrial, can he force Hughes to a bench trial and deny him a jury trial? I tried to call in to Scott today to ask about it, but court was starting, so we had to hang up. Okay, which if you guys don't know, and if you don't follow Scott's channel, Recovery Addict, it's fantastic because he will take calls on a burner phone no matter who you are, as long as court's not in the middle of things happening. It's a really fun feature. But great question, D, and the answer to that is you can never force a bench trial on someone. You have a constitutional right to a jury of your peers, right? So you have a right, if you're going to go on trial, to say, I want a jury to hear this. You can waive that and you can ask for a bench trial, but that's up to the defendant. But it brings up a really good question here, is that a lot of people have been talking about, is this grounds for mistrial? And in a situation where the prosecution is asking for a mistrial, where does that leave us on double jeopardy issues? Have you? I can tell you my thoughts on it, but jump in, Scott, if you've heard things in your research or people have told you, or what.
I've heard jeopardy applies already. It's already attached, which would mean there's no way that the state is going to ask for a mistrial. They're going to push through till the end on this because they wouldn't get another bite at this apple. This is a once only deal.
Yeah,
if that's true.
Well, here's, and I'm sure I'm going to just get lambasted by people online. Here's my thoughts on the whole thing. First of all, a defendant cannot create his own mistrial. So if the prosecution, even though these are definitely grounds for mistrial here, this is exactly the kind of stuff that a mistrial would be declared over, is if improper information had come out that the jury shouldn't hear, which creates some sort of unfairness, miscarriage of justice, that the judge cannot cure through a instruction. So imagine this the other way around. If the prosecution had asked this or elicited information that they weren't supposed to, the judge likely would declare a mistrial if the defense wanted it, right? Mm-hmm. Because then it was the prosecution bringing it on and it affected the defendant's rights. Here you have the defendant who's the one causing the inappropriate miscarriage of justice through this evidence. You can't create your own mistrial, so they can't request it. So what is the prosecution going to do? And you bring up a good point. Jeopardy attaches on the swearing of the jury. So when the jury is picked, they ask everybody to raise their hand. Do you swear? Blah, blah, blah. Boom. Jeopardy has attached. You have now started your jury trial officially. But just because jeopardy is attached doesn't mean that you can't have a mistrial declared and get another trial. We see this all the time when you have a deadlocked jury, right? In those situations, jeopardy has attached. It's just the judge is declaring that because they were unable to reach a verdict, a mistrial will be declared and they'll get to go again. Okay. And mistrials can be declared for different types of reasons. Sometimes it's something as much as, the unavailability of a witness or something. A witness dies and it somehow changes the dynamic of the case. So the question really becomes, would this create a situation where a mistrial could be declared upon the prosecution's request that then wouldn't make it a double jeopardy issue? And that comes down to, you may have seen this term tossed around, the idea of manifest necessity, meaning, is this such a miscarriage of justice that's incurable by the judge, that the judge feels like a mistrial is necessary? My view is the judge could. My view is the judge could say, this has created a situation that is so unfair because the people are a party to this. The prosecution's a party to this as much as the defendant. It's so prejudicial to the prosecution that I'm going to declare a mistrial, and he doesn't get the benefit of then just walking away, because that's not how this works. So I view it, and I could be wrong, that it could create a situation where he could declare it a mistrial. But it really becomes a question of, do they want it at this point? Or do they just kind of roll with the punches and avoid maybe appellate issues? That's going to be a question that they have.
Yeah. That in South Carolina, the law is written in such a way that it's really in the state's favor right now. They've got all the elements proven or admitted to, and the law does not allow for that, defense of others without that immediate threat being present, which it wasn't. Yeah. So it should be in the bag unless the jury does something that sometimes juries do, and then who knows what's going to happen.
I feel like I'll tell you what I think the prosecution we should do, but first let's take Simi Sharp's question here. Do you think he did that on purpose in an effort to cause a mistrial? I'm curious. You kind of have a better finger to the pulse of this gentleman. Do you think he was doing this to encourage a mistrial, or just because he felt like this is the truth?
I think the latter is the case. I think, first of all, if this doesn't end in a mistrial, the second trial is going to have the same problem. And I think the state knows that he will do the exact same thing because he wants this story to get out. He believes this story. He believes in the reason why he did this. And he took action before trying to raise this issue. Granted, it was in weird ways, sending pornographic images of Christina to family and friends. That's not the normal way we try to alert someone to a crime that's in progress. But he took action to try to raise this in the eyes of the authority. They did nothing. And now he says, you guys need to know you have to see what was happening here. And I think that is his overriding goal here. So mistrial, no, but get the story out. Yes.
Yeah. I think if I were the prosecution, and it's so easy for me to sit here in my comfy chair and play Monday morning quarterback to them, but if I were the prosecution, I think you quit the charade of trying to hide this from the jury. That cat is well out of the bag. You embrace it and you just cross-examine him on the idea of what you just pointed out. You didn't even know this woman. There was the child being abused as you walk through the door, but you took it upon yourself to stab this woman to death because in your head, perhaps this could occur again, or perhaps it. And I think there's a very clever way to point out that taking everything this man says as even being true, that doesn't excuse the premeditated, brutal murder of someone. And that's what we're here to talk about. But I don't know. I mean, it's their call. What do you think? Did they give any indication as what they intend to do?
They talked. Our court watchers told us there was talk of mistrial, and they said, no, we don't want that. We want to continue. But that was, I believe, the second time he did it, and we haven't heard what their thoughts were the third, because the third was, or the final one was the most egregious. That telling the jury that the court is literally hiding crucial facts from the jury, trying to get them to make a decision without all the knowledge. That's pretty bad.
Yeah.
So I think they are going to sleep on it overnight and, hit that war room and discuss this. And we might have a different decision tomorrow. I think the judge, I don't think it's too late to tell the judge, we are going to ask for mistrial.
Because they did seem to be kind of running around like the little boy, trying to poke the dam from leaking and keep
running
everything together. And despite this flood of information coming out, Dr. Patrice Berry, thank you so much for joining us. She says, I wonder what the jury's reaction was during his testimony. Do you have any insights as to how they were, what the looks were on their face as this was all going down?
Yes. This is what's crazy. The entire time that Zach was testifying, the jury was watching with rapt attention. And I think a couple people reported they're not even blinking. Like the jury is fixed on him hearing all this, because it was an unreal experience to hear somebody describe in detail the process mentally, internally that they went through, as well as the physical action they took as they committed a murder. It put you right in the, in the body of a murderer. That was the experience we felt as he was describing this. And the jury was just, I mean, they were both stunned. There was one point when he brought up the abuse issue, the jury just mouth agape turned to look almost collectively at the audience who was doing the same thing in the gallery, just like, is everyone hearing what we're hearing? It's unbelievable. This jury is getting their money's worth out of their service. This is incredible.
Yeah. DK has an interesting thought, and I'm curious. It kind of goes back to this idea that you talked about earlier, where the defense deferred to make their opening statements later. I always think this is kind of a clever strategy on the defense. Sometimes the defense, there's two ways of thinking about it. They can go right after the prosecution so that the whole narrative is set from the beginning. But I also think that there's sometimes a very clever way to say, I'm going to wait till my turn. And then now, after they've heard everything, I get to kind of reset the narrative and give my story. And I've heard everything the prosecution has to say, so I don't have to feel like I'm eating my words later on. DK, again, thank you, says, I feel the defense could have gotten the DNA evidence thrown out, they wouldn't have omitted anything. That's why they waited to do opening statements. What do you think? Do you think this was a game time thing, or do you think that Zachary was going to take that stand no matter what?
I think defense knew Zachary was going to tell this story. If it didn't come out in court, he was going to tell it himself. I think there's no question in my mind. They knew that this was an inevitability, that we were going to get to the point where, we would have that moment where it's yelled out in court over objection, if need be. He's willing to kill to get this message out. What's defying the judge's order compared to that? But yeah, the defense, they fought the DNA hard. This is one of the few issues. I believe there were 3 objections on trying to bring the DNA in, where they tried to attack the foundation. They tried to say it was a relevance issue, which is crazy. DNA found in the fingernails of the victim. That's usually relevant at a crime scene. But they were throwing everything at the wall to try to keep this out, because honestly, this was the smoking gun in the state's case. There's no reason for Zach Hughes' DNA to be under the fingernail of a deceased lady that he doesn't know in her own house.
But without that DNA, it was kind of left to an eyewitness who kind of describes him, and some video that kind of looks like him, right? Like, there was no one who came to court and said, that's the gentleman I saw enter the home and kill that woman, right?
There was one neighbor who had a really good memory years later and didn't report all of that at the time. So it's sort of her memory enhanced over time. And that was called out at the time by, I think defense did, as well as, a lot of people in chat said, yeah, I'm not sure. Maybe she might've seen some things and it sort of helped her remember. But yeah, there wasn't like that sort of video that we can see him. We can see a guy on a bike wearing a hat. He's wearing black clothes, and it's a black bike. And, there are lots of black bikes and lots of guys wearing clothes like that.
Right. But
she did identify him and said, yeah, he was the one I saw. But other than that, there wasn't anyone else IDing him that way.
No, like you said, smoking gun stuff. Ashley, thank you so much for the super sticker. JC Broadway says, what if imminent threat is ever present? And this is a great question, because I know a lot of people are frustrated with this idea of, how is this not in defense of others if somebody is suffering from kind of ongoing abuse? And the way defense of others is written, it's always with that idea of imminent threat, because you have to understand, we're justifying murder, right? Like, this is a complete defense to murder. And so, other words, you're saying you had, a moment in time where you felt like you had to do something to stop the threat to yourself or the threat to others that was a deadly threat, and you had to act in that moment. When it's an ever-present type of thing, now we drift into that the spousal abuse syndrome type defenses that we've heard about before, where, you think about the Sarah Boone type thing that she used unsuccessfully, but it's this idea that I was in this ever-present cycle of abuse that caused me to act in a way that may seem inexplicable if you don't understand the holistic nature of what I was living in. But it's different than self-defense. But I understand everyone's frustration, and I think that's kind of what Zachary's hoping too, right? Is that the jurors will feel like he was righteous in his actions.
The way he describes it, I think he feels that the daughter was in this imminent threat because it was ever present in her life. But imminent threat is, I think that would be more appropriate for, someone in captivity, like someone who's kidnapped and is being abused, and then they get an opportunity finally, and you get an opportunity to escape or attack your kidnapper. And he wasn't attacking you at the time when you did it, but there was that imminent threat that would apply. In this case, she wasn't even home; she was at school. And he never witnessed any of it, regardless of whether or not it happened. He was taking someone else's word for it. And
yes, that's to me is crucial too. Is that there's this level of separation, degrees. He's degrees away from actually having knowledge of the abuse. Like, it would be one thing had he been witnessing it happening and knew that child was coming home that evening. And if she did, it was going to happen again that evening, as sure as it had every evening before, kind of a situation. And I've got to act now. But when you've never actually, witnessed it, you don't know the person, you're only being told about it. It separates you, I think, enough that jurors probably have enough to find him guilty, even though they know about this information.
Yeah.
Lee T asks, and this is something we didn't get into, who got arrested outside of court today? So this was on top of all the other craziness. There was also some more craziness for Mr. John Mello. Tell us about that.
I didn't realize it was right outside of court. I didn't know where he was, but while Zach was on the stand, literally while he was still testifying, part of his testimony was that Mr. Mello told him, offered him $5,000 and then $10,000 to kill Christina. That's, seeking a hitman for hire was what he was looking for. Zach turned both of them down, said he wouldn't do it for money. He says the only way I would do it is if I knew that it was the only way I could do it and there's no other option, which apparently he came to that conclusion. But yeah, this arrest, as soon as Zach, gave that evidence, this was something the police had not heard to this point. This was not in the WhatsApp messages. This was not in, the text messages back and forth of the emails or the packets of photos and everything else. This was new to the police, and they acted immediately on it and took him into custody. He's now been charged with accessory. And I don't know, specifically what the charge is, but
which is also really interesting and probably something we don't have time to get into tonight. But one, it raises the question of, to me, why didn't Zachary come forward with this before? Why didn't his attorneys float this information to the prosecution in perhaps an attempt to get a better deal? Hey, by the way, I wasn't acting alone, and I can give you the other person involved in this. Maybe they felt that it would have more of an impact at trial. I don't know. It just seems bizarre that everybody's just now learning of it. And two, how reliable is this information coming from a guy on the stand who's, obviously trying to say whatever he can to save his life? Are they going to go off of that testimony in order to put charges on this other guy? Seems a little shaky. Christy G kind of clears it up. He was picked up at his home today. Regardless,
Christy was in court today
for us. Picked up from what took place on the stand today.
Christy's our viewer. She's in court. She was watching from the courtroom today, and wow.
Thank you, Christy.
I will say there was Mr. Hughes's testimony today was very believable to me. And he did testify at one time that he lied. And he said he filed a false report about abuse, saying he was a neighbor and he witnessed it when he hadn't and didn't. But he was trying to get the ball rolling on the investigation. Aside from that, Zach, in all of his stories, is the hero and pretty much the best at everything he does. And he is. When it comes to piano, when it comes to top of his class in the military, enrolled in the Marines, he ended up getting injured and not being able to continue after 3 weeks. But he's been the best of the best of the best in almost anything he tries. The jobs he applies for, he applies for 5 conservatories, music conservatories, gets admitted to 3 of them. He's, one person selected from the U.S. to travel internationally to represent the U.S., and it's him. He is amazing at what he does. But it seems like, I've got to say, something is off. His thought process that got him to where he is and being charged with what he is, something is missing, and I want to know what that key is.
It's almost like this duty / martyrdom sort of thing taking place, right? Where it's like he almost feels like, I'm fine going down for what happened as long as people know why. As long as the truth comes out as to why I did what I did, then I'm fine if I have to sit in prison for it. He's like the feeling I get.
Yeah. Yeah. And it's crazy. He is so at peace with that. And that comes across very clearly in his testimony on the stand.
Yeah. Yeah. Analytical Blarney AB, thank you so much, says, as a special education teacher, he's not autistic. His tone, inflections, eye contact, etc. show that. He's a non-righteous vigilante, and I'm terrified to see what happens if he's released. The God complex will be out of control. That's an interesting phrase. I've never heard that before, about a non-righteous vigilante, but that's kind of what we were saying, is that there is this whether you want to call it vigilantism, whether you want to call it martyrdom, it's like he had a higher calling to do what he's doing.
Yeah, in his testimony today, he shared several times about religion and that he was raised in a religious household, and before, during, and after the murder, I think he even said he prayed after he killed her before he left the house, trying to sort of make peace with his decision, knowing, saying that I knew that I had to do this, even though, my body repelled against doing it. I had to fight through my natural instinct to pull my punches to actually stab her hard enough to kill her. And that's why it took so many, there were so many superficial wounds, because he just couldn't bring himself to actually stab hard enough. But it's wild. He does feel like he's like done the world a favor.
Yeah.
Through what he did.
Yeah. T. May says, how does the judge effectively muzzle him at this point if charging him with contempt does nothing to stop him? Not to mention, if the man was willing to murder for his own internal compass, it seems like that, a threat of 6 months in jail ain't going to stop him. And Dr. Bullbutter, thank you again, asks kind of a similar question. If this is a mistrial, Zachary Hughes will do it again with another jury. So how would this help? And so I'm going to kind of add to that question and throw it all at you, Scott, and we expect an excellent answer to all of this. But, he's got a right to testify too. There's these concerns of you can't just muzzle a defendant and say you're not allowed to go up there and defend yourself. But it does seem like there's no stopping him. And even if they declare a mistrial, we'll be going through this whole mess again. Do you know if that was at all discussed or what people's feelings are on that?
I know it was discussed in chat that he would do it again today, just watching people who were watching the trial. Going back to Darrell Brooks, we saw a similar thing where he pushed a right that he had so far that the judge finally said, I am going to rule that you have waived your right to this. And it's a constitutional right. And it is an extreme measure. And I know that was a different state. I don't know how South Carolina addresses that, or if their laws have addressed that, if there's room for a judge to make a ruling and say, I am ruling that you have waived your right to testify to yourself. That's a huge ruling. That has appeal written all over it. So I don't know what measures they can take going forward. I guess tomorrow, hopefully we'll tell. But
yeah. I think if the prosecution is smart, I think what they would probably do is anticipate this the next time around and maybe address it ahead of time. Like, they can't say you're going to hear from the defendant because he's got a right to testify or not. So he could pull a switcheroo on them and not take the stand the next time around. So
that would
they
be
cannot
wild,
guarantee it, but they can say that they can't get out ahead of this evidence and say, listen, we're also going to tell you about there was evidence that there may have been something inappropriate taking place with this child, and that may have caused the defendant to feel that what his actions were justified, but we're going to tell you why that doesn't apply in this case, or something to get out and ahead of it so that when he does take the stand, it doesn't have these shocking moments of, the prosecution doesn't want you to hear this, you're all being lied to, kind of a thing that to me is the most damaging thing that he said today. It's not so much the idea of this, what was happening with this kid. It was the idea that now they're being told the prosecution is keeping it from them.
Yeah. I think they're going to get told that again. I think it's going to happen on cross. I think if the state pushes him into a corner and sort of makes him connect with what he did physically, because he's tried to distance himself from the murder, right? Because in his head, he knows that murder is wrong, and he's had to convince himself to go through this. When he was describing it, he says, he doesn't say when I killed her or when I was stabbing her. He says, when I was striking and when I was doing it, and it was out of control. He's using language that it's still difficult for him to reconcile that he killed her. So there's a part of him that knows that it's wrong. If the state forces him to address that and sort of confronts him and pushes that right in his face, I think we're going to hear him revert right back to that reasoning that he used to make the decision in the first place. And that's where he's going to blurt out, what happened, what he was stopping. And then we're going to have another objection.
Yeah. And so where do things stand right now? That no determination has been made as to what's happening tomorrow. It was kind of like left with, let's talk about this. Is there a hearing set for the morning before everything continues?
There was a little bit more after that big bombshell moment and the objection, and Mr. Hughes' testimony on direct is done. So the witness has been turned over for cross-examination. That's what's going to start, assuming there's not any other business the court needs to handle or issues, if there's talk of mistrial, things like that, that would come first tomorrow. Otherwise, we expect the state to get up and start grilling the defendant about why he did what he did.
Last question that we have on this, and thank you so much, Scott, for sharing that. Your insights are incredible. MLC asks if the state embraces that, though, and I think what MLC is referring to is the idea of just going with what's already out there. Are they opening the door for actual physical documentary evidence of what happened to the daughter to be admitted? I'll let you have the first shot at it, and then I'll kind of give my thoughts too.
First of all, I wouldn't wish that on any jury if they do. But I don't think they could. There's a point where evidence is very prejudicial. And I think the judge drew the line. We've passed that line. Going one step further and showing them everything, I think is well beyond that. I don't think they could do that and expect to get a fair trial for the state in this case.
Well, I got a question for you before I jump into this, and it just made me think of it. Do we know if Zachary ever actually saw any of this evidence? Like, did he see any of the things that were found on the phone allegedly? Did he actually witness everything, or is he being told all of this by way of hearsay?
Everything we've heard is that he's been told this by Mr. Mello, and there was one time he observed the daughter on a FaceTime call between the parents, and all that he observed was that the light had sort of gone from her eyes. She was, it was the joy that he saw in her before was gone, and he attributed that to the effect of this treatment that she was undergoing at the hands allegedly of her mom and her mom's fiance.
Interesting. Well, what I was going to say is that one way the prosecution might treat this is to highlight that, is to say, okay, sir, you believed all this was taking place, but you were being told that by Mr. Mello, correct? Did you actually see any photographs? No, I did not. Did you actually witness anything? No, I did not. What did you? Well, I saw her on FaceTime, so based upon the life going out in her eyes, you decided to stab her mother X amount of times and leave. You know what I mean? You start to maybe highlight the ridiculousness of him putting so much faith into what this other man was telling him. And, now you've got the issue of why isn't the other man on trial alongside with him? But I think that might be an easier issue to handle than the issue of all of this other evidence out there.
I think the state has a challenge with that because the lead investigator in this case is also the lead investigator on the other case. And that's the first witness the defense called was the lead investigator. They tried to use him to open the door. They tried to ask him about this other case to try to get this opened up. And he wouldn't give the answers they wanted. And, that they couldn't get there. They wanted that door open so they could get there. If the state does introduce it and embrace the theory, then you've got that lead investigator who sort of has to answer questions about it. And that would open the door a little wider and more stuff would come in that would be problematic for the state.
Wow. Crazy stuff. All right, Scott, I'm gonna let you go. I feel like I could talk to you about this for hours. Maybe when this whole thing wraps up, we can convince you to come back again and share with us some more thoughts on this whole thing, or maybe I'll just bug you again to come on to talk about another case. But
that'd be awesome anytime.
This was really an interesting conversation. Thank you so much again,
Josh. Thank you. It's always a pleasure. Have a good one.
If you guys don't know, but I'm guessing that the vast majority of you already do know about Recovery Addict, please make sure to go check out Scott's channel. Scott's just doing stuff over there that you don't see on other channels, and the way that he watches trials and makes it interactive and answers questions and takes phone calls. And if they've got downtime in court, don't sweat it, because he's going to bounce around to another court. So
there's
again,
always something happening.
Always something happening, always keeping it lively. Thank you so much, my friend.
Josh, thank you. Have a good one.
All right, absolutely. Take care. All right. Should we see what's on the poll? I think we have a little time left. We might as well answer one of those poll questions. Kaylin, what was our poll winner? Drum roll. 56% Jeffrey Ferguson. Interesting that you guys picked that one. So this is a case out of, like I said, Los Angeles here. He was and I'll just kind of, because the case is just starting. And if you guys are interested in it, I will follow it more and give you guys more updates on it, and give you more kind of insights as to what's taking place. But it presents some interesting kind of preliminary issues that you just don't see all that often, because he was a judge who is charged with murder. There was, first of all, a problem of, where do we try this man? Because how do you have him sitting in the same court system where he also presided as a judge for so long? How do you pull jurors from the same pool of jurors that he may have had in his court before, or people that he may have presided over as plaintiffs and defendants in his own court? I don't know this guy, so I'm so interested, says Ali B from Tennessee. So it's just one of those cases too, where it's the circumstances around it are shocking, disturbing, and even, I think, sad. And I think what it really comes down to is people who had some serious marital issues, but it was also fueled by alcohol. So the story goes is that Jeffrey Ferguson, the gentleman here, like I said, on the bench for forever, apparently a really well-respected judge. He was out to dinner with his wife. This is in 2003. They had been drinking heavily, and they started to argue about finances. What? Time is old as time. Tale is old as time. I mean, yeah, they, people married for a long time. Finances is one of those things that people oftentimes argue about. And so they got into an argument about finances. Well, they then go from the restaurant and go home, and they're at home watching television with their adult son, and the argument continues. And at some point during that argument, there's the adult son. During that argument, he makes a gesture towards his wife, the finger gun gesture. And she says something to him along the lines of, why don't you go ahead and do it for real? Judges in California are one of the few occupations that are given a concealed carry license nearly without question. It's kind of a funny thing, but nearly every judge you see in California is likely packing. Many of the judges I know are packing. And, it's one of those occupations where there's people out there, especially if you're in criminal courts, people are going to be upset with you. They blame a lot of their circumstances and why they're going to prison on the judge. And he happened to be a judge that carried a weapon. And he pulls out the gun, and the way that it has been described in filings and reports that we have been able to see is that he pointed it at her and shot. Now, is that and this is what it's going to come down to, is that the actions of premeditated murder? You might say, of course, Ritter, it clearly is. Or is that a drunken person kind of threatening something ridiculous and awful and dangerous and not realizing the gun was going to go off. And that is what his attorneys are arguing. This is not a case of self-defense. This is not a case of mistaken identity, any of those other things. He freely admits to it. In his 911 call, so the son calls 911 and he's admitting to it. He's heard saying during the 911 call, I killed her, I did it. So there's not an ID issue, any other kind of defense like that. He texts his court clerk and bailiff to tell them he's not coming to court the next day, which is also pretty remarkable to me, because it's like amongst the chaos of his world, he's also thinking about court the next day and how he's going to handle it. And he texts the bailiff saying, I just lost it. I shot my wife. I won't be in tomorrow. I'll be in custody. I'm so sorry. And this is according to, again, police reports. If we had pictures of the actual text messages, we would show it to you. It's just one of those things where, again, someone lost their life here. How do you show at all any kind of sympathy towards this man? And I don't know if it's sympathy as much as I'm just sad about the entire situation, that something like this got completely out of hand. A woman has lost her life. Now this man may lose his freedom for the rest of his life. He obviously led a pretty law-abiding life if he was a judge before now. He says at one point, when officers arrive, according to body cam footage, he says, never in my wildest dreams I thought I'd be sitting here in handcuffs. Now, one other interesting thing about this, and because I said like it was an Orange County judge, initially the case was sent up to LA County, and it was sitting in front of a judge here in LA County. In fact, it's the same judge who is handling the Monica Cementelli case right now, Judge Eleanor Hunter. Very, very accomplished, good judge. She was handling the judge, and they put him on $1 million bail at one point, but it included bail conditions that he not drink. And I think he even had a scram, what they call a scram device, attached to him that would measure the blood alcohol in his system. They will oftentimes do this in cases with people have driving under the influence allegations, and people are injured, or it's their third time or something like that. Lee T says, did the shooting happen in front of the son? I don't believe the son witnessed it, but the son was present and called 911. And he had his bail revoked because it was found out that he had been drinking while out on bail, and had to this time post bail. First time it was set at $1 million. Then it was reset after the violation at $2 million. So maybe drinking is a very serious problem for this person, even if he's to the point of not being able to stop the drinking while he's out awaiting murder trial for his own wife. So really, really sad case. This man is likely going to be convicted. I don't think the whole I did it on accident thing is going to fly with jurors. I think they're going to realize a guy pointed a loaded gun at his wife. And whether you call that first degree murder, or you call that, some sort of reckless manslaughter, he's going away. He's an elderly man. He's going away for probably the better part of his life. Scott says that's one way to get a day off work. It certainly is. It guaranteed him no work the next day. All right. I'm just going to give you guys the treat of seeing ASAP Rocky in court. I don't know if that was next on our poll or not, but I think that's a good way for us to go out this evening, is for you to see the jubilation experienced by ASAP Rocky as the verdict was read in court. Can we talk about Rocky for like 2 seconds? That was insane. Yes, we will talk about it for, in fact, 59 seconds, according to this video. This was the moment that the not guilty verdict was read in court, and you get to see ASAP's reaction.
The Los Angeles Superior Court, County of Los Angeles.
Can you guys hear?
No,
that's just kind of cool to see that moment when somebody with a lot riding on the line. You remember this guy was looking at 24 years in prison. That's what he was facing. This case, from just a personal, having been a prosecutor perspective, infuriates me because I feel like it was wrong to pursue this thing. And I know the prosecutors involved, and I respect them highly. And I know the people in that office, and I respect all of them highly. But this was, listen, part of the job of being a prosecutor is being a gatekeeper. You are the last decision before somebody puts their entire life on the lines and could go to trial. This could have turned out differently. There are jurors out there who could have convicted this man, and he could be looking at a very significant amount of time in prison. And so prosecutors are supposed to be gatekeepers. And Katrina Bunny says the victim threw out his credibility out the window. I agree with that, but it was a bad case to begin with. It was a bad case that got worse. Those injuries were horse poop. That is just ridiculous to try to bring an assault with a deadly weapon case when you've got scratches on your knuckles. You bring assault with a deadly weapon, I better see a bullet hole in somebody. You've got scratches on their knuckles. You got a very weak video that shows something happening, but I certainly can't tell who's holding the gun. Your star witness is biased, got his own issues, got his own motivations, and falls apart completely on the stand. What was the charge again? It was assault with a deadly weapon. He was looking at 24 years behind prison. And if you don't believe my word for it, how weak the case was, then believe the words of the DAs themselves, who said, would you take 180 days jail to get out of this? 180 days jail, by the way, is like what you'd give someone on a relatively serious misdemeanor. Okay. That's not a felony offer. That's an offer of that 180 days jail. With the overcrowding of the county jail here in Los Angeles, you might be out in a couple of weekends. That was a please take this so we can save face offer. And he said no. And I'll be the first to admit, I felt that was a mistake at the time. I felt like most defense attorneys would have said, I'll do the 180 days if this will avoid trial, because who knows what will happen at trial. And he said no, and he turned it down, and he took his chances. And that kind of celebration is what you get when you take your chances. I missed a question, Kaylin, if we could go back. Yeah, here we go. May I ask one more on Zach? What is your opinion on why he brought this to trial when he admitted to it and there is no insanity plea or any defense, really? That's Ali B from Tennessee. Thank you so much for asking the question. Great question. I think this man is not operating in the way that we can apply normal logic to. I agree with you. Why, if you have this information about being told that somebody will pay you to murder someone, why aren't you coming to the DA with that? Why aren't you coming to them and saying, you could do what's called a proffer and say, I've got valuable information. If you allow me to explain that to you, do you promise not to use it against me? And if you feel that it's valuable enough, will you cut me a deal? This happens a lot. And he could have come to them and said, this guy Mello was willing to pay me for it. He's the one that fed me all the information. He's the one that encouraged me to go do it. He's the real culpable party. I was the one holding the knife, but he's the one pulling the strings. But he didn't. And he waited until this final moment. And I don't know if that goes all a part of his righteous indignation or what it was, but he made some bizarre decisions. Analytical Blarney AB, thank you again, says, I don't envy this judge. The defendant and lawyers calculated. Don't forget they were in chambers for 2+ hours, changing defense one day ago, manipulation. I'm not sure which case we're talking about, but yeah, I agree with all of it. Thank you so much. Anyhow, that's my little tirade on ASAP Rocky. God, it comes across at the end of the day too as an embarrassment, I feel, for an office that I used to be a part of. They know better. They should do better. They've done better in the past. And now this will be kind of a black mark on their reputation, that they're just going after another celebrity and overcharging as always and coming up short. And what an embarrassment. And it did not need to be that way had they made the decision much earlier on of just not pursuing this case. And had they charged it and felt in the middle of their pursuit of it before they swore a jury, if it was a case that they shouldn't have pursued, then they should have made that decision then. Oh, it was Zach's case you're talking about. Okay, sorry. So go back to the question again, because I want to make sure I answer this question. I don't envy this. No, I don't envy this judge either. You think, oh, the defense attorneys calculated. Don't forget they were in chambers for 2+ hours, changing defense 1 day ago. Manipulation. You know what? It very well could be. It very well could have been a sabotage on the court. I don't envy this judge either. I don't think this judge wants this kind of nightmare and this kind of headache, and I'm sure he's losing sleep over it because he's got some very incredibly important decisions to make depending on what the prosecution does tomorrow. If the prosecution wants a mistrial, this becomes an incredibly difficult decision for the judge to make. And yes, how do you as a judge cure any of this through instructions? You know, Scott put it best. This is like putting toothpaste back in the tube. There's just no undoing this. And I don't care how many instructions you give to the jury. There's no way that you can cure this. And so it very well could lead to a miscarriage of justice if he does allow it to continue, because what if the jurors get it wrong based on all this information they shouldn't have heard in the first place? In any case, thank you all so much for being here on a Wednesday. Let's do some quick announcements before we go. What you missed on Monday, this last Monday, we had our conversation series with Mike King of Profiling Evil. It was fascinating. It was emotional. It was inspiring. Please go check it out. This Saturday, we have our normal weekly roundup show. Check that out. Next Monday, for our new episode in our Courtroom Confidential Conversation series, we will interview Matt Murphy. Big fan. I'm a big fan. The channel's a big fan of him. He is a former Orange County prosecutor, prosecuted many, many huge cases, has now a fascinating career, has a book out. So we'll be talking to him at 5 p.m. Eastern, 8 p.m. or 5 p.m. Pacific, 8 p.m. Eastern. It's a live premiere as we always do. But come half an hour early, we do our countdown show before that. And if you're enjoying these conversation series, in the meantime, we'll check out the conversation we had with Scott. It was a really wonderful conversation where he shared a lot of interesting stories about his background and how he turned all of that into what is now today Recovery Addict. Thank you to our newest members, Diane Mayett, Renee Mundy, BGOG, Mandy Reberica, Kala Newell, Texas Two Pugs, Macy, Sphinx Jeremy, But First Coffee, Jadzia 1969, Allison Powers, Lenore Forevermore, Debbie Newman, and Dorothy. You guys have all been fantastic. If you want to learn about how to join our membership program, well, then all you have to do is go to thecourtroomconfidential.com. And I'm going to show you right now. If you just click on become a member, it will shoot you right over to where you can join. So you can also be a member and join the likes of P. Lola's mom, Katrina Bunny, Miss Take, Deborah Guzman, Julie Frood, Paula B., Sam M., Lynette Crick 2324, Tisha TSHA, IGG Rocks, Idaho Spud Girl, Christine Fortunato, June Sildalakis, Sue B. Sue, and Kim Lady. You guys are all truly fantastic for taking the time to be such big supporters of the channel. Check out thecourtroomconfidential.com for membership, for how to leave us a voice message. Loved hearing from you guys at the last Sunday Fun Day and would love to hear from you all again. In the meantime, thank you so much for joining us on a Wednesday evening for taking the time. You're all fantastic. Have a wonderful rest of your week. Take care.